Good afternoon and welcome to the 24th Annual George Mason Law Review Antitrust Symposium. We're excited to have you with us today to kick off our 4-day virtual event. My name is Tim Swartz, and I am the Symposium Editor of the George Mason Law Review. Before we get started with today's program, I want to take a moment to thank everyone who has made this year's symposium possible in this new format. First and foremost are our generous sponsors, Freshfields and Charles River Associates. We deeply thank them for their ongoing support of this symposium. Ever helpful have been Professor Wright and Judge Ginsburg for their sage advice, and the Global Antitrust Institute staff, Judy Jin, Matt Line, and Daniel Tonsing, who have been the logistical dream team supporting every aspect of this symposium. We also thank our technical vendors, 5 O'Clock Films, Story Frame, and Andres De La Roche for getting us up and running virtually. Finally, and most importantly, the symposium would be nothing without the participants. Thank you to everyone who's donating their valuable time to talk antitrust on camera this week. The Law Review and I personally see so much value in public discourse by the foremost experts in the field. We're all in for a treat this week, beginning with this keynote. Thank you to Attorney General Weiser for joining us today. I'm very pleased to turn it over at this time to Professor Joshua Wright, who will introduce our distinguished keynote speaker. Professor Wright is University Professor and Executive Director of the Global Antitrust Institute at Scalia Law School. Before rejoining the Scalia Law faculty in 2015, he served as Commissioner of the Federal Trade Commission. Professor Wright?
Thanks, Tim. And let me double down on Tim's welcome a bit here on behalf of the Global Antitrust Institute. We are thrilled to have you with us virtually. I bring the virtual background with me to remind me how badly I missed the place, and hopefully we can have you all in the building next year for the symposium. We miss doing that and hope to be back at it again sooner rather than later. But we're thrilled to have you all here with us virtually now. And Tim is too bashful to say or too humble to say, but let me embarrass him for a moment. He, as all of the panelists know, this is for the symposium editor of the Law Review. This is their show. The GAI helps out on the margins. We've got great sponsors, as Tim mentioned. We help put it together, but as any of the panelists know, they've all been in contact with Tim. It's their program, and I think they've put together a great one. And I'd like to thank Tim for all of his hard work and the Law Review staff for putting the event together. And with that, I think no better way to kick it off than a keynote from Phil Weiser, who I've got the pleasure of introducing to you this morning. Phil is the 39th Attorney General of Colorado, and he's also a friend of the Scalia Law community. I got to know Phil in his previous life as a professor of law and dean of the University of Colorado Law School, where he founded the Silicon Flatiron Center for Law, Technology, and Entrepreneurship. That center will not be a stranger to many of our participants and panelists. I got to know Phil there and was a speaker at a few events, and am really excited about being able to have him to deliver a keynote this morning. It is a time when everything is up for grabs in the world of antitrust and competition policy. The standards, the procedures, the traditional role of the states in enforcing the antitrust laws. So I think there's no better time than to have someone with Phil's perspective, both as a state AG, but also Phil served in senior leadership positions in the Obama administration, was appointed to serve as the Deputy Assistant Attorney General in the DOJ, and is Senior Advisor for Technology and Innovation at the White House's National Economic Council. Earlier in his career, Phil co-chaired the Colorado Innovation Council and served in President Clinton's Department of Justice. After graduating law school, he worked in Denver for Judge David Ebel on the 10th Circuit. and held clerkships both with Ruth Bader Ginsburg and Justice Byron White, among many other accomplishments. Phil, we are tickled to have you, and thank you so much for agreeing to start us off with the keynote, and I will give you the floor.
Thanks, Josh. It's a pleasure. And I feel for the students who aren't getting the benefit of these in-person conversations and a chance to network. You're all getting a intellectually rich experience, and the tradition of Scalia law, thinking about Justice Ruth Bader Ginsburg, is one that we need more, which is open, honest, engaged discourse across different perspectives, not always agreeing, but always being engaged and never being disagreeable. And that is a legacy we get from both Justice Ginsburg and Justice Scalia. What I want to start with is where Josh focused on. The state of antitrust law today is larger in the public imagination than perhaps ever. And Carl Shapiro even said, than it has been in a century. At this moment, there are well-documented bipartisan concerns. So in Colorado, Ken Buck active on the Republican side, Joe Neguse on the Democratic side, both seeing decline in competition and a rise in increasing firms with market power. In my talk today, I want to talk about how we got here and what's today's opportunity for antitrust law and competition policy to meet this moment. First, what I'll call the uses and abuses of the Chicago School. In the 1960s, there were, let's say, small business overall as an end in itself, views out there. The idea is that any mergers should be barred. And in this era, there weren't economically rigorous analyses of most famously the Vons grocery case. Supreme Court stopped a merger there of two grocery chains that had a combined market share, wait for it, 7.5%. This, of course, represents a big is bad attitude, and it fueled a critique famously known as the Chicago School of Antitrust Law. And the essence of this critique is, let's focus on actual economic consequences and not rigid formalities. In dissent in Vons grocery was a precursor to this critique. It came from Justice Potter Stewart, who commented that the opinion made no effort to appraise competitive effects in terms of the impact on the economy or the retail food industry in the LA area. And Justice Stewart skewered the majority for adopting what amounted to a per se rule against mergers in the face of any trend towards concentration, ignoring that small businesses were actually competing effectively against large chains, and overlooking that there weren't significant barriers to entry. Finally, Justice Stewart took a few shots at the majority to put some more nails in the coffin, noting that and here I quote, the emotional impact of a merger between the third and sixth largest competitors in a market, however fragmented, is understandable, but that impact cannot substitute for the analysis of the effect of the merger on competition. And most famously, he concluded, the sole consistency I find is that litigation under the antitrust laws is that the government always wins. That was the 1960s. In the 1970s, Chicago School critique was building up steam with scholars and later judges like Robert Bork and Richard Posner calling for economic rigor and a focus on market realities. This critique paved the groundwork for a revolution in thinking, for the development of merger guidelines that were jointly adopted by the Department of Justice and the Federal Trade Commission for the first time in 1992 as a joint matter. They later revised them in 1997 and 2010. And that set of guidelines is focused on an economic foundation for merger review. And the role of government enforcement is not only around policing anti-competitive conduct, but it's really about helping develop a system, rules of the road. These rules enable firms to self-police themselves based on their understanding of the boundaries. And antitrust lawyers and economists are enlisted to help firms do just that. In principle, this is what the merger guidelines can be so valuable in doing, which is providing guidance. Now, in practice, I recognize firms may want to push the envelope to test and determine what actions antitrust enforcers will take when push comes to shove and whether or not they will challenge a merger as illegal. My essential point today is that our cause for concern is not overly aggressive antitrust enforcement along the lines of Vons grocery, but that we have increasing industry concentration that harms consumers, workers, and innovation. To take a case in point, consider the airline industry. Group of commentators, this is part of preparing for the transition, noted between 2005 and 2014, the Antitrust Division of the US DOJ reviewed 7 airline mergers. 5 of those cases, there was no challenge at all, and the Antitrust Division settled the other 2. As we sit here today, 4 airlines control 70% of domestic airline travel, and that's probably an overstatement because that's 70% across the whole nation. In any individual market, there may just be 2 or 3 airlines who offer relevant flights. And painfully, there's very little entry in this sector, as I'll talk about in the next part, in part because incumbent airlines have developed a reputation for predation. Finally, in what I believe is a very clear and compelling demonstration of consumer harm, we had a natural experiment recently. Fuel prices fell dramatically. In a competitive market, when an input falls, like fuel prices, consumers get benefits. In this market, they didn't, other than free peanuts. And at the same time, the industry recorded massive profits. Let me offer another case in point that I believe is a powerful reflection on the state of our economy. It's a case called Steves and Sons versus Wen. And I'm just talking about it as Steves. This is about the door manufacturing business. Now, in 2000, this industry was robustly competitive. They had a lot of door manufacturers who were independent, and they could buy the critical parts they needed. And notably here, interior molded door skins was a critical such part. At that time, 2 major companies made this component part, Masonite and Geldwell. Now, Geldwell back then, as now, is vertically integrated. That means it both manufactured the door skins and it used them to build their own finished doors. Now, in 2001, one of those companies, Masonite, was about to be sold off, including its premier Towanda manufacturing plant. And it was going to be sold off to Premdor, who's one of the then independent door manufacturing firms. Now, in response to concerns from other independent door manufacturing firms, the US DOJ required that this Towanda plant be divested from Premdor and create a new firm, Craftmaster International, or CMI. And the idea is that CMI could both produce and sell door skins to independent door manufacturers, preserving valuable competition. And that's what happened for the next decade. And you ended up with 3 firms selling these molded door skins. Then things took a turn. In 2012, Wen decided to look at buying CMI. But before doing so, they entered into long-term supply contracts with these independent firms like Steves. And what they knew is that they could assuage the DOJ by, in effect, preventing complaints. They were successful. The DOJ contacted firms like Steves and they said, we're not worried about this merger because we've got a long-term supply agreement. After the merger was consummated, however, Wen closed one of the existing plants. And even though it had declining cost, it went up, it raised prices to Steves and other independent firms. Wen also changed its policy on reimbursing firms like Steves for the cost of doors that were rendered defective by flawed door skins. And in making these changes, Wen took advantage of the fact that it was the only independent supplier of door skins. And they basically told Steves, hey, look, Masonite, this other firm, they've actually told investors they're no longer selling door skins to independent door manufacturers. So Steves was in a delicate position, and they took an unprecedented step of they challenged this 2012 merger from 4 years earlier as illegal, calling for the divestiture of that CMI facility from Wen to restore the status quo ante and competition. And Steves demonstrated that there had been adverse competitive consequences, the ones I just talked about. And they provided evidence they couldn't meet their needs for door skins, either from foreign sources or by building their own supply. And the court ruled in their favor, acknowledging the divestiture is the most dramatic but most effective of antitrust remedies. Here's what the court said. In the spring of 2012, there were 3 vertically integrated door skin suppliers, Masonite, Wen, and CMI. The record shows that these 3 companies competed vigorously in selling door skins to Steves and other independent, non-integrated door manufacturers. And that's pointed by the fact that in 2011 and 12, Steves was negotiating for a new long-term supply contract, and there was significant price competition at that time. That all changed. And we now have a non-competitive market. This decision, it's on appeal from the district court to the Fourth Circuit, could change it. What happens in this Steve's case is going to be a telling tale of the state of merger law. And to put it broadly, think about this arc from Vons Grocery to Steve's. What that shows both is the value of the Chicago School critique, focusing on economic rigor, and what many have, I believe, rightly called an overreach. The idea that Steve's company could have that district court decision overturned on appeal scares me, and it should scare us. Because if you try to defend that merger and you oppose all antitrust enforcement, I believe what you are doing is taking an unjustified extension of the Chicago School of Critique. Another way to say it is, in a case like Steve's, we have economic rigor, we have marketplace reality. So we're not asking about what I'll call over-enforcement like Vons Grocery. We're asking about maybe there's been under-enforcement. Maybe the 2012 decision by the DOJ to approve that merger looks wrong, and this case can fix it after the fact. What we have to ask, though, what about other mergers out there like that? Clearly, Steve's and Company and the door manufacturing business, the airline business, are not the only ones where we've seen concentration that's hurt consumers, that's hurt workers, that's hurt innovation. Let me move on from mergers to Section 2, the monopolization provision of the Sherman Act. Over the last several decades, the Supreme Court has undermined Section 2 of the Sherman Act by erecting what I would view as artificial hurdles for enforcers. And a case that is particularly concerning is that of predatory pricing, where the decision Brook Group versus Brown and Williamson, I believe, has created undue hurdles. Scott Hemphill and I wrote an article on this. People can go look up for more details. But here's the short version. In Brook Group, the Supreme Court imposed both this price cost test, which means you got a price below cost. So far, so good. And a recoupment test. And here's, again, potentially undue challenge. You've got to show a likelihood of profiting from the practice. Now, in doing this, both of these two tests, the court purposely suggested they didn't think predatory pricing ever happened and maybe was implausible. And that, of course, fed into the recent lack of such cases. Back to airlines. There was a time in the 1990s, we saw a lot of low-cost carriers enter into this business. That doesn't happen anymore. One of the reasons why is those incumbent firms, the dominant firms, have shown an ability to engage in predation. What in particular have they done is illustrated very well through a 10th Circuit case involving American Airlines, where American Airlines ramped up their capacity and reduced prices dramatically after a low-cost carrier entered the market. The 10th Circuit concluded that there was no unlawful pricing here because of how they viewed the opportunity cost of rerouting an airplane. In other words, if you don't view the opportunity cost as a real cost, airplanes can basically price whatever they want because it's all fixed costs and not marginal costs. With that unfortunate conclusion of the 10th Circuit in hand, the court didn't even go on to consider the second test, the recoupment test, which can be independently problematic. Our argument is that a reputation for predation by conduct in one or more markets, which can deter entry, should suffice to meet that test. Now, whether or not an incumbent has the ability to deter entry and competition by developing a reputation for predation is something that I believe there is and should be concerned about. In the case that we filed, the number of state AGs against Facebook, part of what we were focused on is this very basis for Section 2 liability. In short, our argument was Facebook had a campaign threatening to buy or bury their rivals. As a result, rivals were given a choice, either be purchased in their infancy or, as the complaint explained, face the wrath of Mark, meaning a denial of access to critical opportunities, such as the ability to use Facebook to sign into a service that could undermine that rival's business. Facebook's goals, in other words, would be to buy upstart rivals before they emerge as a serious threat, think Instagram, for example, or to degrade their ability to compete in the merits, think Vine, for example. Like the Steve's case, the case against Facebook involves a careful review of what happened in the wake of a consummated merger. In particular, this case evaluates the impact of the buy or bury strategy And it recognizes that Facebook abused its monopoly power by purchasing upstart rivals, Instagram, I mentioned, WhatsApp for another, to protect its dominant position. Consequently, the complaint outlines both a violation of Section 7 of the Clayton Act, the unlawful merger, and Section 2 of the Sherman Act, calling for divestiture relief as well as oversight of Facebook's platform to address the concerns around discriminatory conduct designed to exclude rivals' ability to compete on the merits. With regard to the case against Google, that echoes the case of 20 years ago against Microsoft. In Microsoft, it was the unanimous DC Circuit that concluded that Microsoft had taken a series of actions, including entering into exclusionary contracts, degrading access to its platform, and keeping barriers to entry artificially high, thereby excluding technologies that threaten to erode its operating system monopoly. The Microsoft decision highlights the significance and importance of presenting a thorough factual analysis that demonstrates how an incumbent monopolist engaged in exclusionary conduct not justified on efficiency grounds. In the case of Google, it's taken a series of actions that have sought to defend and entrench its monopolies in search and search advertising, including entering into exclusionary contracts and inhibiting the ability of other companies to acquire customers of their own. In both these cases, Microsoft and Google, the companies faced threats to their dominance from an adjacent sector and responded, not by competing on the merits, but by undermining the ability of rivals to compete. To remedy such conduct and restore competition requires not merely ending the illegal conduct, but taking affirmative steps to lower the relevant barriers to entry. Let me conclude by noting that we're living in a moment that calls for bold antitrust leadership. The trend in antitrust doctrine, however, has involved unwarranted obstacles to enforcement. And that's leading Congress to consider whether legislative action is necessary and appropriate. One important role for antitrust enforcement in this moment is to recognize the importance of bringing cases where you can prove clear harm to competition, cases where the economic rigor called for by the Chicago School is driving the analysis. In that sense, the cure for what I would see as an unwarranted extension of some Chicago School thinking is to actually focus on what got the Chicago School critique started: an attention to marketplace realities, not rigid formalities. To appreciate the value of such an approach on realities, consider the Evanston hospital case. Before that case, the FTC had lost 7, count them, hospital cases in a row. Former FTC chair Tim Harris was asked about this. In particular, some said, why don't you just give up on hospital mergers? He and the agency declined to do so, and consumers are better for it. Instead, the FTC conducted a series of retrospective studies, and they identified that there was this consummated merger with demonstrated harm to competition. This is the Evanston case. By using the empirical realities of that case, showing price increases, very much like the Steve's case I mentioned, that case was able to drive doctrinal change and to actually undermine what had been a rigid formal test. This was the misuse of the Elzinga-Hogarty patient flow test, and allowed for hospital mergers to be condemned as anti-competitive. And following this Evanston case, the Microsoft case, and the Steve's case, I think the challenge for antitrust is clear: to demonstrate factual situations that can call for a reassessment of legal standards that may be tilted against the risk of over-enforcement and not sufficiently attuned to the risk of under-enforcement. As a new administration considers how to elevate and revitalize competition policy goals, there's an opportunity to reinvigorate antitrust enforcement and promote competition goals more broadly. As some commentators have explained, this opportunity is even a broader assessment than antitrust law to promoting competition more broadly. And it could involve White House leadership of an Office of Competition Policy that could sponsor robust and careful studies of industries to better understand how and why competitions arise. Obviously, I've mentioned airlines and manufacturing, but consider agriculture or healthcare as 2 other candidates for review. At this moment, it is also crucial, as Josh and Tim noted at the outset, for robust commentary, for debate about what a post-Chicago School agenda needs to look like to give rise to an antitrust law that's attuned to today's market realities. Thanks for the opportunity to join me. I welcome the discussion. It's going to be ongoing and very much look forward to when it can continue in person.
Thanks so much, Phil. A characteristically thoughtful introduction for our symposium, and we are grateful to have your thoughts. Not every day we get an attorney general who is proficient with the Elzinga-Hogarty geographic market definition test. So I have, can now sell to my students when I teach geographic market definition that it is a barrier to entry the attorney general market. But thank you for joining us, and to our audience as well. I believe Phil, your remarks will be posted now or soon. And we will be back this afternoon at 4 o'clock Eastern. I will be moderating our first panel discussion on anticipating priorities in the Biden administration, some of which Phil mentioned in his speech. And that panel will include Bill Baer, Maureen Olhausen, and Bill Kovacic. It's a good one, so don't miss it. We will see you at 4, and thank you all very much.